If you get arrested for drunk driving, there is now one defense that your attorney can no longer use.
It stems from a local case which was appealed all the way to the Supreme Court of the United States. San Diego 6's Chase Kane has more.
Nearly 5,500 people get locked up for drunk driving every year in San Diego County, and the majority of those arrests follow a field breathalyzer test. But now, because of a U.S. Supreme Court decision, or really a non-decision by the Supreme Court, defense attorneys in California can no longer challenge the broad use of breathalyzers.
So they can challenge the particular machine, but they can't challenge the science behind the machine.
City Attorney Jan Goldsmith welcomes the federal decision to let a state Supreme Court case stand because Goldsmith says he's seen too many cases of defense attorneys getting an acquittal for drunk driving because of shaky expert testimony.
Jurors are sitting there and thinking, well, this expert sounds like he knows what he's doing, saying, and so maybe cameras don't work. Maybe the earth really is flat. So you have the risk of confusing the jurors.
Still, the city attorney says when drunk driving charges do make it to a courtroom, more than 99% of people are found guilty. So what does this ruling mean for your defense if you were the one facing a DUI charge?
It doesn't really change the landscape that much. It just takes away one, I guess you could call it a tactic that some attorneys would use to say, just generally, you can't trust breath testing.
But that's not an approach Cole Casey uses anyway. This well-known DUI attorney would rather his client's defense rely on more substantial evidence.
I would prefer a blood test simply because it gives me something to hold on to. I can have that blood then retested by a private laboratory. The breath test, I can't do that. I have to take a piece of paper from a machine and hope that it's accurate.
But in Casey's opinion, there's an even bigger Supreme Court decision which could affect you if you get arrested for drunk driving or really for anything, and that relates to your cell phone. The Supreme Court decided the police can no longer search your cell phone without first getting a warrant. Reporting outside the Hall of Justice, Chase Kane, San Diego 6 News.